नहीं सर, तहरीक डिनायल नहीं है.
But देखिए, there are two kinds of speeches, ना? I mean, is a judge not allowed to make a speech?
Yes.
देखिए, I think we should not forget the facts. The fact is not making of the speech. If it's making of the speech, then probably half the superior judiciary will have to go home, because how many judges have made to the Bar Council's speeches? I mean, these are not too. So
that speech was made before a bar is.
No. So it's not a question of mere making of a speech. It's the content of the speech. I think both go together. Now it depends what I say. If I say there should be, I go and tomorrow I make speeches, independence of the judiciary, this, that, the other, fine. I may even canvass a view which is different. But if I make allegation against someone, so I think you can't disconnect the two things. It's the nature of the allegation. Because I would say if otherwise, then we will have to read that Article 19 is not available to judges.
That's what
I mean, okay, you may not agree with the judge's point of view, fine. I mean, but you remove him on that ground. The code of conduct doesn't say you can't make a speech. So on it, I don't think there's anything wrong per se in making a speech. Now, if you make some speech and you attack, launch a vicious attack or loaded attack or whatever you want to call it, that we cannot disconnect with it. We have to see it together. I mean, I can't just say, oh, making of a speech. I mean, making of a speech is your right. Anybody's right.
And
I mean, it's not exactly.
District Bar Association.
By the way, you may be interested to know the United Kingdom, which is so conservative, judges give interviews. I mean, it's House of Lords. I mean, those restraints have far gone, and judges of the American Supreme Court, as judges of the Supreme Court, Justice Stephen Breyer and Justice Scalia's debates,
all make public.
Debates were pretty vicious on various law schools they were given. So let's connect it with the speech. Now, nobody's taking us to the next level. What do we do? Can we personally ourselves inquire into the matter?
Sir, one thing which I just want to point out, there were a number of speeches made by Justice Kiani which was published.
I agree with you on that.
Very clearly.
No, I agree with you. It will be, I think it is connected with the content. भाई अगर आपने बिला वजह ऐसे इल्जाम लगा दिए to another I don't want to use the word institution, but it's important,
yes,
whatever department of the government आप कह लें, जो भी आप कहना चाहें. So naturally it is not a nice matter, but if they are true, it changes, I think, the complexion of the matter.
Sir, page 70 अगर देख लीजिएगा,
this is solution मैं आपको ही नहीं बता रहा.
नहीं सर, solution तो ये है कि इस वक्त ये जो order है president का, based upon the report of the Supreme Judicial Council, need to be quashed.
देखें, Hamid Khan Sahib, it's not so simple. Then we'll be faced with an allegation that the Supreme Court threw Khwaja Saab's clients under the bus and saved one of their own. Again, we have to be very fair to both sides, because you made allegation targeting specific persons. So if we quash it, that effectively means that all that you said was true, without an inquiry, one way or the other. Now, how can we, I mean, what do we do then?
So then the answer can be, I'm just making a humble submission, that let this order of the president be quashed, let the report be also quashed, and let the matter be remanded back to the Supreme Judicial Council to hold an inquiry.
Can this order be passed?
I believe so.
हमें असिस्ट करें.
लेकिन अगर सुप्रीम जुडिशियल काउंसिल बगैर इंक्वायरी के रिकमेंड कर देती है रिमूवल ऑफ
okay, are you saying it's inherent in fundamental rights and due process?
Yes.
Power of remand. Can you remand the matter to the Supreme Judicial Council?
That can be consequential on the requestment of the order. It can be.
Khwaja Sahab, आप क्या कहते हैं इस point पे?
There are two ways.
नहीं, let's see. Khwaja Sahab is senior counsel, let's see what his view is. Can we remand the matter to the Supreme Judicial Council or we can't?
My Lord, may I very humbly make a submission? It cannot be done because now there is nothing for the Supreme Judicial Council to inquire into, because the petitioner's tenure has already expired. He's no longer, it goes back, he would no longer be a judge to be considered for purposes of removal, which is the function of the Supreme Judicial Council. So it does not fall within the functions of the Supreme Judicial Council at this stage. This is what my very humble submission.
So what is the solution? None?
This matter requires the determination or not?
Let's suppose we, for sake of argument, don't take it amiss, that we set aside the order. That means that that's implied in the order that all that he said, the judge, when he was a judge, was true. So you are condemned. Won't you be condemned?
It doesn't imply that, my Lord.
Why? Then you say everything I said was true, therefore the order was set aside?
Yes. What he said, my Lord, so far as the allegations against specific persons are concerned, they came up for the first time before the Supreme Judicial Council.
No, he's been saying it from day one.
No, he hasn't. The specific allegations against persons, by naming them and naming the incidents also, they never figured in the speech, they never figured in the preliminary reply that was given to the Supreme Judicial Council. It was in the second reply, the additional reply that...
No, but one way or the other, why didn't the Supreme Judicial Council say something on it? They could have asked him, say it on oath.
Yes. What did the Supreme...
I don't know, I called you to cross-examine him. I don't know, whatever way.
I'll make a submission. What the Supreme Judicial Council did was, they asked for the then Chief Justice of Islamabad High Court for his reply on the allegations that were made by the petitioner vis-a-vis him. And he denied all those allegations.
But it's one denial,
I'm just making
one assertion.
Yeah. No, but more importantly, may I make a submission? I'd said that before also, and I'm trying to be as balanced.
See, you can't just say because he's Chief Justice, I believe him, and because he's a simple judge, I disbelieve him. That's no...
Now we come back to the speech itself. The sole ground on which the matter against the petitioner could have been sustained, this order can be sustained, is if this Honorable Court comes to the conclusion that that speech per se was sufficient for his removal because it came within the definition of misconduct.
Are you suggesting a judge cannot give a speech to a bar counsel?
No. What I'm making a submission. May I make a mistake? Irrespective of whether it was true or not what the petitioner said, irrespective of that, because it maligned the judiciary as a whole.
How does it malign the judiciary?
Let's go through the speech itself, if your Lordship would. It maligned the Army Institute, the armed forces.
He is maligning you.
No, not in the speech. In the speech, it is the armed forces, it is the judiciary. They are the judges of the Islamabad High Court.
Suppose the allegations are true, then what will happen?
Even then, the petitioner should not have gone public or made a speech before the bar.
Why?
He could have issued a contempt.
Why are you saying he should not? Unless you can specify some violation of some law, constitutional provision, or a constitute of the code of conduct of judges, you can't just say he should not have. You should refer to something because of this reason.
The code of conduct says something to...
Refer to that provision which says that judge cannot give a speech to the bar counsel or whatever.
It's not a question of giving a speech, it is a question of giving a speech which maligns the judiciary.
Exactly, it's the contents of the speech.
Or which maligns any institution in the country. That is...
Okay, now let us...
Only that has to be held.
एक सेकंड खान साहब, एक सेकंड. Please refer to the code of conduct. Code of conduct मुझे निकालने. Which provision are you relying upon?
But may I very humbly submit, my Lord, I am not taking sides in this case.
No, I know.
Because your Lordship has called on...
No, actually, yes. It's always beneficial to have a senior counsel like yourself.
I'm just...
Because we are just thinking aloud how to proceed.
Yes.
And we'll be next be calling upon the Attorney General as well. So, which possible misconduct provision can you bring him under?
There's one provision in the Code of Conduct, Hamza, which relates to public speech.
Article 2 maybe you can read Article 2.
I'll read that and then I'll read Article 2 for your Lordship, my Lord, but I think there's another provision which talks about, this number 5. Yes, it's Article 5. May I very humbly submit? if it is to be stressed, it will fall under Article 5, nothing beyond. I will come back to that also. Functioning as he does in full view of the public, a judge gets thereby all the publicity that is good for him. He should not seek more. In particular, he should not engage in any public controversy, least of all on a political question, notwithstanding that it involves a question of law.
It's not publicity he was seeking. He was, let's call him a whistleblower. Every whistleblower, you will say, is seeking publicity. What publicity he was seeking by this? You are assuming he was seeking. Burden will be on the person seeking his removal to show that he was seeking publicity. It's premised on that. As a judge gets all the publicity that's good for him, he should not seek more. So then it will be you are seeking publicity. In other words, you can't address bar councils. Yes, there will be the media there. So what?
They are not engaged in any public controversy.
No, it says least of all on a it's not the public, it's a political question. Where is politics here? There's no politics here.
It states in particular, he should not engage in any public controversy,
so if
least of all on political matters.
Let's take the worst case scenario. If the institution he is in, there is corruption, he should keep quiet.
No, there is.
So what should he do?
He should be writing to the Chief Justice.
Okay, he says failed.
He should be writing to the
failed.
And if there is somebody,
then what should he do? He should keep quiet about it.
If there is someone approaching him, he has the power. He can issue contempt notice to that person. If anybody dares to approach him, to influence him in any of his decisions,
there's corruption. For instance, not this case. We're giving a simple thing.
What I'm saying,
and his colleague is taking a bribe. He writes to the Chief Justice. He informs the Chief Justice. Doesn't do anything. He gets frustrated. Okay, maybe the frustration level comes to a point that I'll go public now. Okay, so fine, you can, the person against whom he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case.
May I
so which other article can you rely upon?
This is the only article, I suppose, but there is an article which was invoked in the order itself.
Which one was that?
Kindly read second para of Article 2.
I'm going to read that. Right. Second para,
Second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity